title of my presentation is The Constitutional Protection of the Creation and Future Generations in Hungary, especially the current challenges of GMO regulation. During today's valuable lectures, we had a description of the constitutional regulatory environment for the rights of future generations, including the Hungarian regulations from several well-known university lecturers and professionals. We all have a common goal to achieve and ensure the protection of the interests of future generations at the highest possible level. Over the course of the next 3 days, the conference participants will make a concrete effort to review the constitutional regulation of their nations and its relationship with nature, and jointly present on the constitutional framework within which it is possible to protect the planet from threats such as air and water pollutions, deforestation, extinction of species, extreme water and weather events, and much more, all identified by climate change. The collapse of ecosystems and species and the acceleration of climate change are a clear sign of the need for a fundamental change in the relationship between humanity and the natural world. Allow me to examine the right of future generations from a different perspective during the next few minutes. My presentation relates to the ongoing discussion of the preservation of biodiversity and the protection of gene heritage. Human activity related to genetic modification represents a serious threat to the conservation of biodiversity in the absence of sufficient regulation. This is why the attitude of science, society, legislation, and the application of the law towards a very new and exponentially developing field of biotechnology is of paramount importance. In the interest of time, I will abstain from reviewing the detailed arguments in favor and against genetic engineering, the cultivation of GMOs, as well as the details of the complex regulation. These are largely known to everyone. In the official position of Hungary, the protection of the uniquely rich wildlife and genetic heritage of the Carpathian Basin has been present for decades. Also, EU law has been transported. Hungary has launched and succeeded in the dispute relating to the permissive EU decision on amphora potatoes, which has never Hungary been allowed to be introduced into public production in other member states. For example, the inclusion of mines varieties in public production, which has never been approved. Hungary supported the change in EU legislation, and in addition to the legislation that in principle allows to the implement of temporary ban safeguard clause, in addition, strict coexistence rules were introduced into the gene law. Of course, this commitment does not enjoy full support, as there are those who believe that the decision is not professionally well-founded, because this means that we are giving up precision cutting-edge technologies. The cutting-edge technologies in agriculture, degrading the competitiveness of our agriculture, as Professor Kovács analyzed in his 2018 study. Article 20 of the Fundamental Law lays down the requirement of agriculture free of genetically modified organisms. The provision of the Fundamental Law is subordinate to the right to health and appears as one of its means. However, the nature of the asset in terms of food distribution is doubtful. In addition, it is a state objective that can be interpreted independently, which the state must also bear in mind in its internal measures and external relations, such as its role in shaping EU legislation. Hungary considers the regulation of activities related to genetically modified modified plants of major strategic importance. The fundamental law protects the preservation of GMO-free status in Hungarian agriculture. In 2006, Parliament formulated Hungary's GMO-free strategy and implementation and maintenance process. Since then, this strategy has not changed. Moreover, Article 20 of the Fundamental Law, which has been in force since the 1st of January 2012, also declares the right to physical and mental health. It ensures this right through agriculture free of genetically modified organisms, access to healthy food and drinking water, occupation safety measures and healthcare, the support of sport and regular exercise, as well as the overall protection of the environment. The regulation of genetic modified organisms in Hungary dates to the Act 53 of 1969 on the protection of nature. Section 9 of the Act regulates the establishment, the experiments, cultivations, import, and exports of such products. These can only take the place under the conditions and manner laid down in separate law. Hungary was the first country in Central Eastern Europe to adopt a law regulating genetic engineering activities. This was the Act 27 of 9098 on the activity of genetic engineering. This is called the Gene Act, under which all genetic engineering activities are subject to authorization. In order to bring the Gene Act in line with EU legislation and to regulate certain issues more effectively, the National Parliament has amended the Act several times since its adoption, thus helping to achieve the goals of the mentioned parliamentary resolution adopted in 2006. At the same time, the genetic law ensures that genetically modified plants currently approved for public cultivation in European Union and another genetically modified variety that the European Union may permit to allow in the future cannot be included in public cultivation in Hungary without limits. 2012 amendment to the Act provides for the increased protection of traditional and organic farming, as well as the protection of gene banks. Indications referring to GMO labeling are regulated by the FAM regulation. In compliance with the obligations of harmonization, Hungary has transposed the provision of the EU directives on genetically modified organisms into the Gene Act and related domestic regulations, and the EU regulations on GMOs also apply directly in Hungary from the date of accession, namely the 1st of May 2004. In addition to the above, the implementation of GMO-free agriculture as defined in the Fundamental Law is protected by Hungarian law with an additional significant legal measure. Act 100 of 2012 on the Criminal Code provided for the legal facts of the violation of the obligation to genetically modified plant varieties in section 362. According to this, the misdemeanor is committed by a person who has put the propagating material of GM plant variety with an EU license or an EU cultivation license into the environment, or has violated the rules of the moratorium. Following the amendment of the Criminal Code in 2013, according to the legal facts in force today, a person is punishable by imprisonment up to 2 years for this misdemeanor, who on the one hand illegally imports, stores, transports, places on the market or releases into the territory of the country the propagating material of a genetically modified plant variety that is not authorized in the European Union. On the other hand, if the propagating material of a genetically modified plant variety not authorized for use for cultivation purposes in unlawfully released into the environment, and who, in respect of propagating material of GMOs authorized for cultivation purposes, violates the prohibition on import, production, storage, transport, placing on the market, and use ordered as a safety measure for the duration of the seal procedure. The most serious, subjecting to the provision of the criminal code. In other cases, the regulatory on genetic engineering fines shall apply. Judicial interpretation also plays an important role in the enforcement of the interest of future generations with regard to the relationship between science and practice with genetically modification. Relating to Hungary, the Anflora decision was the first and the most significant decision on using GMOs. The General Court annulled the Commission's decision authorizing the placement of genetically modified Anflora potatoes on the market because the Commission had breached the rules of procedure for the system of authorization of GMOs within the EU. Another important interpretation of EU law on genetic pollution was in decision the Kovács and others versus Freistaat Bavaria. The German court concluded that the presence of pollen from MOL 810 mines could only have such consequences in beekeeping product contain such pollen fall within the scope of regulation. 2003. The German court initiated a preliminary ruling in its judgment of the 6th of September 2011. The European Court of Justice ruled the pollen contained in honey should be considered as an ingredient. It has not respective capacity and it is not capable of transmitting its genetic material at all. So it is no longer part of the concept of GMOs. Pursuant to Regulation 2003, it is classified as food containing ingredients produced from GMOs, and the same classification can be applied regardless of whether the entry of the substance in question was international or national. In the meantime, new technology for the mutagenesis has raised new legal interpretation questions. Unlikely mutagenesis is technological produce that allows the genome of a living species to be altered without foreign DNA implementation. The procedure of mutagenesis made it possible to develop seed varieties resistant to certain selective herbicides. Tracking them is almost impossible. In 2018, there was a case that the court held that organisms obtained by mutagenesis are also GMOs, and are in principle subject to the same obligations set out in the GMO directive. However, organisms obtained by mutagenesis which have been used in traditional applications and whose safety had long been proven are exempt from the obligation by allowing member states to submit them to the obligation done in the directive. In breaking with the traditional approach, the Advocate General assumed that the validity of an EU act could be challenged not only on the basis of the facts and knowledge at the time of adoption, but also on the basis of the legislator's failure to fulfill its obligation to keep it up to date with its reasonable framework. In this case, this general obligation relates to the enforcement of the precautionary principle as a special obligation. Keeping regulation up to date in the areas covered by precautionary principle is the key. In addition, the Advocate General pointed out that according to judicial practice relating to the safeguard clause, in order to take action on the basis of the precautionary principle, specific risks must be identified, of which in this case there is very little information. The Court did not accept the argument of the Advocate General. In the first question, it took the view that mutagenesis falls out of the scope of the directive, not in general, but only in respect of the technological produced, which have traditionally been used in many applications and whose safety has long been proven. The Court ruled that the new technological procedures of mutagenesis may have similar risk to those of transgenesis procedures, which is underlined by the judgment that the development of these new technologies or methods allows the production of genetically modified varieties at a pace and proportion it cannot be compared with those resulting from the use of traditional methods of random mutagenesis. It is also worth highlighting from the argument the precautionary principle mentioned several times above and the references of the directive. The 2018 European Court of Justice ruling left open legal interpretation questions for new genomic technologies, such as new genomic techniques, the NGTs. On 29 April 2021, the European Commission presented its introductory impact assessment on the state of NGTs under EU law. The Council requested this study in the context of the 2018 judgment of the European Court of Justice and the practical issues raised therein. The document examined the implementation of EU legislation on NGTs on the basis of consultation with member states and stakeholders. It also provided information on the status and use of NGTs in plants, animals, and microorganisms in agri-food and industrial and pharmaceutical applications. It defines NGTs as capable of altering the genetic material of an organism and which have appeared or developed since 2001 after the adoption of exciting EU legislation on genetically modified organisms. The main conclusion of the study points to the limitation of the ability of legislation to keep pace with scientific progress, stating that this creates implementation challenges and legal uncertainty. According to the study, there are strong indications that the legislation is not fit for purpose for some NGTs, and their products needs to be adopted to scientific and technological development. According to the Commission, this research confirms that NGT products have the potential to contribute to the development of sustainable agri-food system in line with the objective of the European Green Deal and the farm-to-table strategy. The scientific community, which is already divided over the regulation of genetic modification, received mixed reactions to the publication of this study. During its conference at the end of 2021, the European Commission assessed the current challenges of regulating GMOs and the possibility of regulating new genomic techniques entities in the European Union. Proponents of gene editing and precision breeding want to achieve authorization in the EU through legislation that would allow consumers and agricultural workers to access information on products produced by NGTs and to use these technologies safely. Under the regulatory idea, food produced with gene treatment technology would be allowed to enter in the market after less strict pre-port safety checks and would not be subject to EU labeling standards that would otherwise be required under EU legislation. At the same time, in additional regulatory challenge in the agricultural uptake of NGTs is that only developers are really able to trace them, as they include technologies that can no longer be identified in the products afterwards. The possibility of European legislation intended to treat products produced with NGTs as sustainable food was raised at the conference in 2022, while the Court of Justice of the European Union ruled in 2018 that NGTs should be considered as genetic treatment, meaning that their use is as valid as any other similar technology. As a result of technical interpretation and decisions, these organisms are in principle subject to the GMO directive and are subject to the obligations of that directive. Opinion in favor of GMO deregulation see the application of new technology as a means of achieving climate goals, while several EU member states, for example France, Germany and Hungary, have objected to it. These member states argue that the way to reach EU climate change and climate targets and reduce significant emissions and pollutions related to the agri-food sector is not through gene management, but through supporting sustainable agriculture. In December 2021, the Council of Environmental Ministers also met to discuss the subject. Hungary joined the declaration submitted by Austria, which pointed out that in the development of the impact assessment, greater attention should be paid to the implementation of the precautionary principle, to appropriation prepared risk assessment, to research on detectable and detectability. At the same time, research on the use of new genomic methods is currently available only to countries supporting biotechnology. What is at stake in the development of the EU policy position is whether member states can maintain their agri-food independence. If they were denied access to the biotechnological innovations according to the effective rules and practices of the European Court of Justice that reject NGTs, which follow the precautionary principle and supported by member states. The European Commission intends to put the full impact assessment into public debate during the autumn 2022. The Commission's approval of the impact assessment, which has been developed and duly supported through social participation, is expected in 2023. In its resolutions on mutagenesis, the Hungarian Academy of Sciences suggested that if the results of the new technological procedures are not considered to be GMOs, with the proper application of the Genetic Engineering Act, as a result, these new technological procedures are not governed by the provisions of the fundamental law. It therefore seems as if the new genetically modified procedure could be excluded from the requirement on a scientific basis. It remains the responsibility of the scientists, but of the legislators and the law enforcers who decided the matter. They need to take scientific positions into account. Also, legislative defeats and other legal provisions play a significant role in the interpretation of the provision of the fundamental law and an interpretation of the wording. The fundamental law is not bound by the laws. A good example of this is that based on the development and possible changes of the life conditions to be regulated, there may also be a legislative obligation arising from the unchanged provisions of the fundamental law. More decisive from the point of view of the question is how the values of the fundamental law develop. Which are the values that the state must keep in mind together? Article P of the Fundamental Law, which establishes the obligation to preserve genetic diversity and native plants and animal species, includes the result of gene editing in the list of genetically modified organisms referred to in Article 20, since these also pose a risk to gene inheritance and the protected legal subject during cultivation, regardless of whether the gene law should be interpreted in this way. At the same time, the rule of Article 20 is not an explicit prohibition, and consequently its dynamic interpretation in the light of time lapse, changes in technology and their judgment, as well other constitutional values may change in the future. However, it is not possible to interpret that, for example, the cultivation of GMO crops is permissible in order to ensure the right to health. For this, the fundamental law would have to be amended. Moreover, the whole question seems very similar to that which has also been raised in the interpretation of EU law in the case 2008. However, the domestic regulatory situation is quite different from that of Europe. The main rule of EU law is the obligation to license, and the domestic one is that of prohibition with a basic law regulation that can be interpreted in a broader way. At the same time, the responsibility of the authorities involved in the implementation is enormous, as the number of GM varieties is increasing. They do not need to be marketed in many countries of the world, and procedures are also spreading, and traces of which are extremely difficult to detect in the genome of the given breed. In recent years, there has been very strong support for precision breeding among Hungarian science and agricultural producers who wanted to meet the need of so-called precision agriculture from gene-edited varieties with a favorable character for cultivation and see the competitiveness of domestic crop products as engaged without precision breeding. At the same time, there has been no impulse from the side of the EU law to encourage the domestic legislation to lift the current restriction or prohibition. As Professor Fodor pointed out in 2018 study, it is worth adopting national genetic engineering regulations to rapid development of genetic engineering and strengthening the Hungarian Genetic Authority, both in terms of its number and its professional and infrastructure background. Overall, the interpretation of the Hungarian fundamental law provision can be strengthened by the decision of the Court of Justice that the result of gene editing is considered a GMO. However, an opposite decision would probably not have been made. If the court had ruled that the result of gene editing was not a GMO, it would not have resulted in gene editing being given the green light in Hungary. But the fundamental law is not an act for the transposition of EU law. Thank you very much.